Right. I think I will just get started with a little bit of an intro, and if people trickle in, that's totally fine. Um, so most of you probably know me already, but I'm Nina Josephson. I'm Philly VIP's Small Business Coordinator, and I am so excited to introduce Zane Johnson of MZA Legal. We've been talking about this for a long time, and we both are excited about contracts. It's going to be a fun webinar, and I think it'll be really informative. I did want to make everyone aware that this session is recorded, so if you don't want your face or image in the recording, please just turn off your camera. Before Zane gets started, I just wanted to touch on services available through Philly VIP if you're not already familiar. We connect small business owners with low to moderate incomes, as well as certain direct service nonprofits to pro bono legal assistance in Philadelphia with wonderful volunteer attorneys such as Zane. So if you hear about a contract, you hear about a legal issue during Zane's presentation and you want a little bit more assistance, you want help drafting that contract, or you want to get a little bit more information, talk to an attorney about what might be right for your business, please feel free to submit an application or shoot me an email directly and I can help you get started with next steps. I'm going to drop into the chat my email and our applications, and I'm going to pass it over to Zane. Thank you, everyone.
Awesome. Thank you, Nina. Good morning, everyone. As Nina mentioned, I am very excited about this workshop. Contracts are my favorite topic when it comes to business and the law. We'll get into why in a second, but I want to start with a couple things. First, I want to start by thanking Philly VIP for just the opportunity to partner in this way to kind of bring this series of workshops to folks. Definitely a pleasure to be going through talking about these different topics that really relate to building a solid foundation for your business. And so hopefully you find this information useful and helpful. Hopefully you had a chance to attend the workshop that we had a couple of weeks ago on business entities. And then there will be two more coming up in September on intellectual property. And then I think the last one is business licensing, if I remember correctly. But definitely tap in, check out everything that we're doing in terms of the workshops, and then also want to encourage you to utilize Philly VIP as a free resource for starting your business. Right, I obviously provide legal services, but they're not free. And so I'm a lawyer, but I'm also an entrepreneur, and I understand that when we're starting a business from the ground up, that budget can be tight, it can be limited. So take advantage of everything that's out there, including organizations like Philly VIP to help you get your business launched and off the ground. Secondly, what would a legal workshop be without a disclaimer? And so I want to just say at the outset here that everything that I provide in this workshop or in this webinar is information, right? So it shouldn't be considered advice. And really in a forum like this, where we're meeting as a group, we're kind of going through general information that's going to be useful to probably everyone who's starting a business. Hopefully that'll help provide some clarification, answer some questions that you have as it relates to setting solid contracts, setting a solid foundation for your business. But at the end of the day, if there's anything that you're confused about or still not sure about after the end of this workshop when it comes to creating contracts for your business, definitely reach out to someone, whether it's myself, again, whether it's Philly VIP, whether it's another professional, whatever the case may be. Get that one-on-one advice to figure out and get that assistance on understanding how this information relates to your specific circumstances, right? And so also want to say, as we go through, feel free to ask questions. But there may come a point where if you ask a question and it's something that's like, okay, there's some stuff in there, I would need some more information to kind of answer this as it relates to the question you're answering and your circumstances. I'll, kind of jump in and say, hey, here are the answers to some of your general questions, but this is something that you should really sit down and talk with someone one-on-one about. So without any further ado, let's jump into it. And so today's agenda looks like this, right? So we're talking about contracts. And really, there are basically 5 different topics that I want to cover as we go through. What is a contract? Because I think it's important to first touch on that. How do we make one? Why are they important? Also included in that, why do I love them so much? What makes a good contract? And then the key terms in a typical contract, specifically a typical service related contract, assuming that most of you are service-based businesses. But so we'll probably be spending most of our time on the last two, but all of these different kind of topics with subtopics within the broader topic of contracts will hopefully help to give you the kind of broad overview and understanding that you need to feel confident entering into reviewing, and kind of putting together your own contracts within your business. So I also want to obviously introduce myself a little bit further. So my name is Zane Johnson. I am the founder of MZA Legal. MZA Legal is a Black-owned virtual law firm that focuses on helping self-funded entrepreneurs build a solid foundation for the future growth of their business. So I help entrepreneurs and small business owners, side hustlers, with everything from creating business entities like LLCs and corporations, to reviewing and drafting contracts, to registering trademarks and understanding what their intellectual property is and how to protect it, and then everything else in between. So a lot of general business legal strategy, helping folks to really understand how do you set a solid foundation that one is going to keep you protected, right? Because I think that when we think about legal and business, we're usually thinking about protecting ourselves from risk. But the other side of that coin is being ready for opportunities, right? And so that's a theme that's going to come up as we go through this workshop, and really as we go through all of these workshops within the series, is that having a solid legal foundation is as much about protecting your business as it is about helping your business to achieve growth. Because at the end of the day, confidence is so important to us as entrepreneurs. If we're not feeling confident about an opportunity, if we're not feeling ready for an opportunity, a lot of times that's going to hold us back from either getting that opportunity, or if we get the opportunity, doing our best within that opportunity, right? So not only as an attorney, not only is my job to help business owners stay protected, but it's also to help business owners make sure that they're ready to answer the door when opportunity comes knocking. And so definitely hope that you will consider me a resource. Feel free to reach out. I've put a QR code on the slide here, and this recording will be sent out afterwards. But feel free to connect on LinkedIn. I'm on Instagram at mza.legal. So definitely feel free to connect and keep in touch. Would be happy to help and assist in any way I can as it relates to setting a solid foundation for your business. So back to the topic at hand, which is contracts, right? So the first thing that I want to cover is what is a contract, right? Because I think that overall there can be some confusion. It's a term that we use loosely, but any term that has like legal meaning behind it, is very specific in terms of, as an attorney or as lawyers, as legal professionals, when we're using certain terms, like what does that actually mean, right? And so a contract, one of the things that people often think about contracts is that contracts have to be in writing in order to be legally binding. Which in most cases is not actually the case, right? So certain contracts do have to be in writing in order to be legally binding, such as, contracts that relate to the transfer of land, or certain contracts, just that face higher levels of regulation and scrutiny. But generally speaking, especially when we're talking about doing work as small businesses, most of the contracts that we're signing, or most of the contracts that we're forming, don't have to be in writing to necessarily be legally binding, right? And so a contract at the end of the day is really just an agreement between two or more parties to bind themselves to certain obligations, and also on the flip side of that, expecting to get certain rights, or expecting to get a certain benefit out of that agreement, right? And so the same way that when you sign a contract, or when you check that box, when you log on to a new piece of software, or you have a handshake agreement with someone who's going to take pictures at your next event, all of those are contracts, right? But at the end of the day, what makes a good contract, and also the extent to which you'll be able to enforce that contract depends on other factors, such as whether or not you have it in writing, and kind of the overall, like, what is in that agreement, right? And so, basically, to answer it succinctly, a contract really is just an agreement, right? Um, but to add to that, so on the next slide, we'll add to that. But before I get to kind of adding in like the elements of a contract, I want to talk about why contracts are important, right? At the end of the day, what makes contracts important in business relates back to what I said about setting a solid legal foundation for your business, right? So, when you think about what a contract actually is and what a contract does, a contract at the end of the day, memorializes the relationship between two parties in a business, right? And really, the cool thing to me, why I think contracts are so interesting, is because what you're doing with a contract, or what you're doing with an agreement, is you're creating private law between you and someone else. And what I mean by that is you're basically saying, here are the, things that we're agreeing to do. Here are the obligations that we're going to take on. And we're agreeing to be held accountable to what we put in this piece of paper, or what we've agreed to over email, or what we've shook hands on, right? We're agreeing at the end of the day to follow these rules that we've set out for each other. And we also understand that if we don't, what we put in this contract, the other party has the right to go and get that legally enforced, right? And so it gives us the opportunity as business owners to enter into agreements and enter into business relationships that we might otherwise have felt hesitant about entering into, because without the contract, there wouldn't really be any way to know that we can hold someone accountable, right? And so contracts, they create private law, they create kind of provide the skeleton of the relationship. And at the end of the day, I like to say that they're the backbone of all business relationships, because again, whether it's a handshake agreement or whether it's in writing, at the end of the day, it lays out what everyone's rights and obligations are going to be as it relates to that relationship, right? And so, how do you actually make a contract, right? So I talked about what a contract is. It's basically an agreement, right? Doesn't necessarily need to be in writing. So then if it doesn't need to be in writing, what are the requirements for a contract to be legally binding, right? And so, in other words, right, to kind of draw a comparison that helps bring out what I mean by this, right? If I say to my nephew who just graduated from high school, hey, nephew, if I had said to him 4 years ago, if you graduate from high school at the top of your class, I'm going to buy you a new car. Which, if I had said that at that point, it would have been a lie, because I don't have enough money to just drop on buying someone a car. But if I had said that, right, and he graduated at the top of his class this past year, if that had happened, would that make a contract? Well, no. In that case, it's a promise, and it doesn't have all of these elements that go into making a contract, right? So at the end of the day, the elements that create a valid contract are an offer, right? So it's saying, okay, I'm going to offer to do this for you. And so, in this case, right, when I use the example of my nephew promising to buy him a car, I'm offering, in a sense, I'm saying, hey, I'm offering to buy you a car. What's lacking in that situation is what's known as consideration, right? And so this is a legal term that really refers to, in exchange for my offer, the person who I'm giving that offer to is offering me something in return that's going to give me some sort of benefit, right? And this can get kind of complex when it really kind of digs into looking at what case law has said and what courts have said. And this is a concept going way back to even before the US became its own country, right? But when it comes to consideration, it's really about when the person who makes the initial offer offers to do something, offers to take on some obligation, or offers to refrain from doing some sort of activity, right? So, for example, in a confidentiality agreement, they may be offering to refrain or to not disclose certain information to third parties, right? That in return for that offer, that person is getting something in return, right? So in a confidentiality agreement, it might be a mutual confidentiality agreement where the other party is saying, okay, in return for you not sharing my secrets, I won't share your secrets. Or if it's a service agreement, right? And someone's coming out to, I don't know, clean carpets. They say, in exchange for me cleaning the carpets, you are going to pay me X amount of money, right? And so in every contract, there has to be an offer and there has to be basically consideration or an offer in return in terms of both parties are getting some sort of benefit out of the relationship or out of the deal, right? Um, the next factor or the next element of a contract is acceptance. And so both parties have to accept or come to or the party who's been offered the deal has to accept the deal. And part of that and kind of its own separate element is what we call mutual assent, which basically means that when it comes to the essential terms of that agreement, both parties have what's called a meeting of the minds, which basically means that they're both in agreement about those essential terms. Again, this is something that can get kind of detailed and theoretical, and so I won't go all the way into all of the kind of theories behind it and whatever the case may be. But just know and kind of understand that it's if I'm saying, okay, I'm offering you this, and the other person, if I say, I'm offering you to clean your carpets, and someone says in return, okay, I want you to clean my carpets, but I also want you to clean the drapes and I want you to wash my car at the same time. We don't have a meeting of the minds there, right? I've offered one thing, they're asking me to do something that is different in that situation, right? So we haven't reached an agreement until we're on the same page about the essential terms within that agreement, right? Things like, what am I paying? What is it that's actually being offered? What is a person offering to do or not do, right? So those essential terms within the agreement. And then last but not least, these two are less elements of a contract, and kind of just more like requirements, right? So a contract has to be legal in order to be legally binding in terms of like the purpose of the contract. So if I make an agreement with someone to do something illegal, let's say I make an agreement to hack into somebody's system and steal data that's going to be useful to someone else, right? That contract isn't legally binding because what that person is contracting me to do is illegal, right? And then last but not least is capacity. So whoever you are making an agreement or a contract with has to have the legal capacity to enter into that agreement. So that includes like being of age, someone being someone who has been ruled, let's say, that they don't have the proper capacity. They might, whether they're they've lost their mental faculties or whatever the case may be, right? They have a guardianship. But whoever you're contracting with has to have the mental capacity, legally speaking, to enter into an agreement. So now that we've kind of covered what a contract is, why it's important, I want to talk through some of the more practical things about contract, right? So we've kind of covered the kind of like legalities of it all, but the real interesting part, hopefully you're still awake, is what goes into a contract practically, like what makes a contract good, and then talking about what are some of those common terms that we see within a contract, specifically a contract that is based around the provision of services, right? So first and foremost, a good contract is clear. All right. And so I always point this out to folks, especially because I know that for a lot of business owners, a lot of small business owners, when they're creating contracts on their own, they're using contract templates that they might find on Google, or maybe they might get a contract template from where they used to work, or a friend or a mentor. And sometimes, I think a lot of times, those contract templates have language in it that, the average person isn't necessarily going to understand, because lawyers like to use a lot of Latin, lawyers like to use a lot of legal terms that we don't use in our sort of common everyday conversation, right? And that is, if you understand that type of language, if you understand legalese, so to speak, then that's fine, that's great. But at the end of the day, you should never sign a contract that you can't understand, right? A contract should be clear to you in terms of what am I agreeing to? What am I getting in return for whatever it is that I'm agreeing to do under this contract, right? And so you should be able to read a contract and understand what's going on in it. If you can't, it's not a good contract, because at the end of the day, right, a contract on one end is important in terms of if everything goes wrong and we need to go into court and get this enforced, we want to know kind of what the outcome is likely to be. But on the flip side of that, especially as small business owners, we don't want to end up in court at all, right? And so if we've got a contract, if I agree with you to, provide a service and you agree to pay me in return, and we've got a contract that neither one of us really understands what the contract says, so now we have to go to court in order to settle whatever dispute that we have, because neither one of us really understands what we've agreed to in the contract, versus having a contract that's written in clear, plain English that we both understand. And then when we have a dispute or we have a misunderstanding, we can look at the contract and we can say, okay, here's what we agreed to. Or even if we didn't agree to something specific here, based on what's here in writing, we can kind of agree to how we want to solve the problem. So really, a good contract should be clear so that it helps you stay out of court, versus just being an instrument that you can use to go into court and get the contract enforced. Second, a contract should be unambiguous. And I'm looking at this slide. I'm like, why did I choose this picture? I made these slides a while ago, but when I say that a contract should be unambiguous, what I mean by that is that it should it's another way of saying that the contract should be clear about when certain things are going to happen or what exactly are the circumstances, and there shouldn't be any sort of, like, when you read through a contract, when you read through a term or a paragraph in a contract, there shouldn't be any sort of confusion about what it's saying in regards to that specific topic, right? So a good example of that would be, if let's say we had a contract, and within that contract, it was talking about, what's a good example for me to use? If we both signed an agreement and it said that I was supposed to deliver 50 boxes of taco shells to your restaurant. Well, what date am I supposed to, deliver those taco shells, right? If I don't put that in the contract, it's ambiguous as to when am I supposed to actually deliver those taco shells, right? Another example might be if I say within the contract that, if I say within an agreement, I just had an example and now it's escaped me. If I say within an agreement that we are, I forgot the second example that I had. But hopefully the first one kind of gives you enough to kind of understand what I mean here, in terms of you've got to provide clarity around, everything within that situation, right? So if the contract is addressing what the services are supposed to be, if someone's coming in, they're cleaning your carpets, what rooms are they supposed to clean? How are you going to know? Another good example is, like, how would you know if someone has completed the work that they've agreed to do in an agreement, right? So, like, scope of work is something we'll touch on later. But if I, for example, if you came to me and said, Zane, I want you to draft a contract with me, within that contract, within that engagement agreement, it's going to say you get 3 rounds of edits, or you get 2 rounds of edits. And if you need an additional round of edits after that, there's going to be an additional fee to pay for that, right? So it's not, on something that would be ambiguous in that situation would be saying, I'm going to draft you a contract. And so how do we know when the contract is complete? Is the contract complete when I say it's complete? Is it complete when you say it's complete? Is it complete after a certain number of drafts? How do we know when that contract is actually complete and when Zane is actually finished providing those services, right? So just another example of what I mean when I say a contract should be unambiguous. It should be clear about obligations and when those obligations have been fulfilled. Next, a contract should be complete. So ideally, it should cover all of the different issues that are likely to arise, right? And this is one of those things when like creating a complete contract is best to work from, especially if it's a type of agreement that you're entering into consistently, right? So it might be a customer service agreement, or if you run a business that is an agency, right? You have an agency type model where you hire contracts to kind of farm out work that your business gets, right? So you may have independent contractor agreements, or terms and conditions on your website, whatever the case may be, contracts that you use and enter into often. Having a template really helps you make sure that those contracts are complete and that they address everything that you need to address within that contract, because you don't want to leave, certain things out, right? So a good example of this would be if I entering into a contract with someone in another state. In that situation, if we get into a dispute and that person from the other state wants to sue me, where would they sue me? Would they be able to sue me in their home state? Would they have to sue me in the state in which I live and I'm doing work, right? And so having a complete contract, you would include a provision in there that says if there's a lawsuit or if there's a dispute, not only here's where a lawsuit could be filed, but if there are any steps that we want taken before that, whether it's mediation, or if we want to say, instead of going to court, it's got to go to arbitration, however you want that dispute to be handled, but a complete contract is going to address that, right? And so you want to make sure that your contracts are complete. And like I said, having a good template to work off of helps to make sure that you don't have to remember everything that has to go into that contract. You can just pull out the template and it has all the things that need to be addressed. And now you can just tinker with and customize it the way that you need to. And last but not least, this one actually might sound odd or a little out of place. But a good contract is fair. And again, with all of these, right, with the previous three and with this one, these are my opinions. So others are free to disagree. But in my opinion, a good contract is fair. And the reason I say that is because at the end of the day, remember, the purpose behind a contract is really to build a solid business relationship, right? So hopefully, the folks who you're entering into contracts with, whether it's customers, whether it's contractors, suppliers, partnerships, whatever the case may be, these are relationships that you see as having a long-term benefit for your business, right? If it's a customer, if they purchase once, you want them to come back and purchase again. If it's a contractor and they do good work, you want them to be open to coming back and doing more work for you in the future, right? If it's a business partner and the relationship is beneficial, you want to continue to work with them so that you can continue to recognize the benefits of collaborating and building together, right? And so at the end of the day, a good contract should be fair. And that doesn't necessarily mean that everyone's treated the same or that everyone gets the same deal, right? When I played football, my football coach used to say to us all the time, I don't treat you all the same, but I treat you all fairly, right? Because everyone's in different positions, different circumstances, has different things to offer, right? And so in a contract and in business, if I'm was lucky enough to get a brand partnership with a company like Nike, for example, right? Or a huge, multinational, international company, I can't expect that they're going to necessarily look at it like, okay, I'm going to give Zane the same deal that I give LeBron James because Zane's not LeBron James, right? But at the end of the day, it should be fair in terms of in exchange for what I'm giving to Nike, whatever that would or could or may be, that they're giving me something that is, feels of equal value to me in exchange, so that we both feel like it's a relationship that we can carry forward. Because when an agreement is unfair, the party who feels like they're getting the short end of the stick at the end of the day, there's resentment that's going to be built up into that. So even if you're on the good side of that unfair agreement, eventually there's going to be, something coming back around that you're going to have to end up paying for, whether it's the end of the relationship or whether they, decide to file a lawsuit, or whether they do something that is vindictive to try to mess up your business or whatever you have going on. Again, a good contract should be fair to both parties and kind of everyone involved, to really help build and foster a relationship that's going to benefit everyone in the long run. So now that we've covered what makes a good contract, I want to kind of wrap up, or our last section here, talk about the essential contract terms, or the typical terms that we want to see within a contract, and specifically a contract for services, right? Assuming most of your service-based businesses. Some of these will also translate to, contracts for products or whatever the case may be. But just generally speaking, looking at, like, if we're looking at a contract, what sorts of things should be addressed within that agreement? So first and foremost, off the bat, a contract should properly identify who the parties to the contract are, right? And so this may seem like something that's like very simple, but a lot of times it's a mistake that people make because they're in a rush, or they're overlooking things, or they're not thinking detailed enough when they're, entering into their contracts, right? So for example, if you have an LLC, and it's a single member LLC, meaning you're the sole owner of that LLC, right? When you enter into an agreement, one of the reasons a lot of people choose to form their businesses as LLCs is because they get that layer of personal liability protection, right? That kind of protects them from and protects their personal assets from the debts that belong to the business. So let's say, in the case I'm entering into an agreement with a potential business partner, if I don't sign that agreement as the owner of that LLC, right? So if at the top of that agreement, it says that Zane Johnson is the party instead of MZA Legal being the party entering into that agreement, the point of me having that LLC has basically been removed, because when I signed that agreement personally as Zane Johnson as an individual is taking on all of the obligations and all of the risk that come within that contract and within that agreement, right? If I sign that agreement, though, as Zane Johnson, the managing attorney and founder of MZA Legal, now I'm signing that within my official capacity within that LLC, which is then going to make sure that that layer of personal liability protection applies if there is a judgment against my business under that contract, right? And so it's important to properly name the parties within the agreement, also providing contact information within the agreement in case, for example, you do have to sue the other party, right? You want to know what's the address at which I can serve that party so that I can kick off the proceedings within that court, right? And so you want to make sure that you properly name and describe the parties, who they are, have that contact information in there as well. Next, you want to make sure that you cover the contract's duration, or what's otherwise known as the term of the agreement, right? So you want to cover in there, how long will the obligations in this agreement last? How long will they be relevant for? Relevant's not the right word, but how long will they be legally binding, right? So the reason why it's so important to kind of cover the length of an agreement is because in a lot of circumstances and situations, having an indefinite agreement can kind of lead to consequences, right? So if we just say, hey, we've got an agreement to, we've got an agreement for Zane to provide, XYZ services to this person. If we don't talk about when those, when that agreement is supposed to end, it could go on indefinitely. A really good example of this, I actually had someone reach out to me recently, where a company that they had agreed to do some freelance services for, and under the scope of that work, there was an end date that was set. That company then tried to come back after the end date and after the final invoice had been submitted, and they tried to come back and say, hey, there's still work that needs to be done under this scope of work, right? And without having outlined in that agreement that the contract duration lasted till a certain date, that person might have still been on the hook, but for having in that contract end date, that's what really kind of put them in a position where they could stand firm and say, no, this contract ended or this scope of work ended, pay me my money, right? And so it's an example of how important it is to have that contract duration set. However, there also are situations where it makes sense to have a more indefinite scope in terms of the length of the contract, specifically as it relates to confidentiality agreements and situations where you'll be making an agreement with someone where you are exchanging trade secrets, right? Because trade secrets, what protects them is the fact that you keep them confidential. So if you have a confidentiality agreement that also covers the confidentiality of trade secrets, and you say within that agreement that this agreement ends in 2 years, so the duty to keep those trade secrets confidential ends after 2 years. Well, that basically means that after 2 years, your trade secrets are no longer confidential, and so they're no longer protected, right? So there are situations where, having an indefinite period on that contract makes sense, but that's why it's just overall an important aspect to cover within the contract. Will the entire contract be indefinite? Does it end on a certain date? Are there portions of the contract that extend beyond the termination of the contract? These are all things that you kind of want to be able to consider. Next, we have two very important aspects, especially in a service-based contract around services, is the scope of work and payment, right? So these two, in terms of the scope, and I talked about duration, that can be a piece of the scope. But when I say scope of work, what I'm really talking about is what are you agreeing to do? And also making it really clear within that contract, what am I not agreeing to do, right? So if you run a service-based business, a great way to kind of put this is the services that you offer, you might offer, let's say, 5 or 6 different services, and a lot of them are probably complementary to each other, right? So if you do power washing, you might power wash decks and you have a price for that, and you power wash driveways and you have a price for that, and you power wash siding and you have a price for that, right? You have different offerings or different services that you provide, and you have different price points for those, right? And so when you sign an agreement with someone and you tell them it's going to be $600, you tell them it's going to be $4,000 or whatever the price may be, you're saying this is the price for this specific service, right? Well, what if they come back to you later and they say, oh, well, I thought that you would, I know that you power wash the deck, but I thought you would also power wash the siding on the, wall back there underneath the deck, or, right next to where the deck is located, right? If you don't have that covered in your contract, sometimes that conversation can be really awkward, because it's hard to say to someone who had an expectation that, hey, well, that doesn't really cover that, and tough luck, right? It's a lot easier when the contract says this is the price for power washing the deck. It doesn't include the price for power washing walls, driveways, whatever else, back patios, whatever else someone else might think would be included in that. So when they ask for you to do extra work, you can say, well, the contract actually states that this is extra, it's outside of the scope of what I've agreed to do at this price point. So, in order for me to do that, I'm going to have to charge you an additional amount, right? And so that is how the scope of work really comes into play. It helps to protect against what we often refer to as scope creep, which is when your clients or customers come back to you and say, hey, can you also do this? Or I thought that this also included that. And being able to really clearly and point to places in the contract that say, hey, I would really love to do this for you. If you want me to do it, I'll send you an invoice. And it makes it plain and clear, and no one has to get upset. No one has to feel like they're being wronged or cheated out of anything, because it's right there in the contract, right? So being very specific with your scope of work, also having very specific terms around payment, right? And I think that this is very important, especially when it comes to covering some of the details around payment, right? So it's not just, okay, you're going to pay me X amount of money, right? It's when is the money going to be paid, right? Is it going to be paid all up front, half now, half at the end? Is it all going to be paid at the end? Are you going to pay the expenses now and the rest at the end? And especially if you are hiring someone outside of your business to do work, the real leverage that you have, if you're hiring someone, let's say it's an independent contractor to do work for you, the real leverage that you have in terms of making sure that that work gets done and gets done in a quality and professional manner, the leverage you have is what you're paying them, right? So if I pay them everything up front, or if I pay them, a big chunk of the money up front, and there's no need for them to kind of come back for the rest, or they're willing to let the rest go. If I get into a situation where they're, the work is not of a quality that I expected, or let's say they come back and they say, actually, I'm going to need an extra payment to release the work that I've created, for example, the only leverage that I have to hold over them is the money that I may still owe them once the work is done, right? And so, how that payment is structured in terms of when you pay is very important on both sides, really. But in addition to that, how can payment be made, right? Can someone pay via Cash App, check? Is it going to be electronic payment, cash? How do you expect payment to be made? And then also really important is a refund policy, right? And so talking about when refunds will be granted, I'm a person who just personally, I think that it's good business to say, if I mess up, because that does happen, right? If I mess up, or if something is not up to the standard or quality that I would expect to put out, I'm willing to grant a refund. And so, putting those terms in there where it says, I'm willing to grant a refund under these circumstances, but outside of that, no refunds, or outside of, whatever that refund policy looks like, putting it in writing. So again, when someone comes back and they say, I want a refund because this didn't work the way I expected it to, you can say, well, actually, we don't grant refunds because the work that we did for you didn't provide, the benefit that you thought it would, or whatever the case may be. We did the work that you asked us to do. And so we're entitled to the funds that you paid us in exchange for that, right? Being able to have that conversation and point to something in the contract helps to avoid things like bad reviews, and helps to avoid things like lawsuits, right? When we're just able to point to the contract and say, here's what we agreed to. And then last, in terms of like main things that a contract should cover, is risk allocation, right? And so this is going to be more important. Oh, sorry, there's one more after this. That's kind of a main thing. But this is one that's going to be really important in certain industries where there's more risk involved than in like your typical business, right? So things like construction, or things like home improvement contracts, right? Being able to, if you're a subcontractor, being able to kind of say, all right, we know what the risks are here, whether it's injury to people or damage to property, whatever the case may be. And as it relates to those risks, here's how they're going to be dealt with, right? So an example that I can think of for this is, if you're renting a house and you hire a property manager to come in, looking through that contract and, where in that contract does it say who's responsible for what risks, right? And this comes to mind in particular for me because we're going to be moving soon, and the house that we own, we're going to be renting it out. And so in reading through that contract, one of the things that I read that I didn't feel comfortable with was that as the homeowners, we would be responsible for indemnifying the property manager against any injury to people or property that happened on the property, anything, right? In any situation. And so indemnity means that I'm agreeing to cover the property manager in this situation against any losses that come from a lawsuit as it relates to injury to people or property, right? And I didn't feel comfortable with that because in that situation, if you're managing the property, there are things that you might do or decisions that you might make as it relates to the property that might cause injury, right? And so if you as a property manager make a decision and it's a negligent decision, it's a careless decision, and it causes injury to someone else, I don't want to be held responsible for that, right? So that's an example there of, how risk can be allocated and how risk in a contract can be put on different parties to make sure everybody feels comfortable with the level of risk that they're taking on, especially where one party has, an imbalance of power, whether it be through money or through control. A lot of times that party, that larger party, should be willing, if you're a smaller business, you can negotiate for them to take on a higher level of that risk because they've got a better ability. It's easier for them to take on and carry that risk than it is for you as a smaller business. And then actually, so this is the last kind of main one in terms of terms and issues that should be addressed within contracts. And that's as it relates to intellectual property, particularly the ownership of intellectual property, any intellectual property that's being created through the agreement, right? So, for example, if I go out and I hire someone to create a logo for me, or if I go out and I hire someone to create a piece of software for me, or if I go out and I hire someone to, let's say I want to make a song, I finally want to make that mixtape that I've been thinking about making since I was 18 years old. And I go out and I go to get that recorded. The general rule, right, when it comes to intellectual property and ownership of intellectual property is that whoever creates it owns it, right? And so if someone creates, let's say, a piece of software for me, and that's a piece of software that, let's say, it's a point of sale system that's customized to my business, or it's a customer relationship management software that's customized to my business, that maybe at some point I want to use that software to franchise my business, right? And that's my growth strategy. I want to make sure I have ownership over that. But the person who creates it just by default is going to be the person who owns that. And so I need to make sure that within my contract, I address ownership of that intellectual property and make sure that that contract transfers ownership to me, right? So saying, including in that contract that it's a work for hire, or including in that contract that under the agreement and under everything that's included in that contract, any intellectual property that's being created is being assigned to me or being assigned to my business, to make sure that I've locked in ownership of that intellectual property, and also having that person agree to execute any documents that may need to be executed to secure my ownership in that intellectual property, right? And then also, kind of in a similar vein, let's say I am, I have a piece of intellectual property that I own that's very valuable to my business, and I'm going to be sharing it with another business. What I want to do in that situation, I'm going to be licensing that piece of intellectual property to them for them to use for specific purposes. So let's say, for example, sometime down the line, I create a coaching business for lawyers who want to start their own solo law firm, their own virtual law firm. And within that, arrangement, what I'm offering are standard operating procedures, right? But those standard operating procedures, I don't want that lawyer to go out and use those SOPs to create their own coaching business, right? So within that agreement, I'm going to say, these SOPs that I provide to you are limited to your use of them is limited to X, Y, and Z, and you shall not use it for A, B, and C, right? And so again, covering with intellectual property, because it's so valuable to your business, your contract, whenever you're transferring or whenever there's intellectual property going back and forth, your contract should cover ownership, use of that intellectual property, and then also confidentiality, if that's something that needs to be covered. If the intellectual property is confidential, secret, whatever the case may be, making sure that that is covered within the agreement and that you have the proper terms in place to protect the confidential nature of that information. So then last but not least, you have your miscellaneous terms, right? Often referred to as boilerplate. And when I say boilerplate, that doesn't mean, or miscellaneous, it doesn't mean that they're not important, but it means that you're going to see them in pretty much any and every contract. And they may vary from, in terms of what they look like, but generally speaking, they're going to look relatively similar. These are terms such as, whether or not the contract can be assigned. So like whether or not you can transfer your rights under the contract to a third party who's not part of the contract, or whether what state's law should govern the contract, what courts you can sue in, or how you will handle disputes, right? And so these are terms. The reason I bring them up kind of in a general category is to make it clear that, because one mistake that people often make is when they're negotiating an agreement or when someone sends them an agreement to review, and the other party says, oh, well, that's just boilerplate, as if you're not supposed to ask questions about it. You want to read through that boilerplate and make sure you feel comfortable with it. And if there's anything that you want changed in there, feel comfortable asking or requesting that be changed to something that you're more comfortable with, right? A contract is always negotiable. Everything is negotiable. So the worst thing they can say is no, but make sure that you're comfortable with that boilerplate, because it's one of the ways in which companies or businesses will sometimes try to get over on people by saying, that's just our standard language. Well, just because it's your standard language doesn't mean that it's right for me or my business. So make sure that you understand what you're signing as it relates to that boilerplate. And so just some other potentially important terms, within a contract, especially longer contracts, certain words may have a specific meaning within the contract, right? So confidential information, for example, that might have a general meaning outside of the context of the contract, but within the contract, it might be defined specifically, right? Or if it's a lease agreement, the leased premises might be a word that is specifically defined to a certain address, a certain floor, and a certain square footage, with an addendum attached showing what the property looks like, right? So there may be a portion in there, specifically if the contract is longer, that just covers definitions. And it's important to look at how different terms are being defined in that contract so that you understand what's what and what's happening, right? Recitals, those are typically like the whereas clauses that you see at the beginning of a contract. A lot of times a contract might say that those recitals aren't necessarily part of the contract. Sometimes it'll say that they are part. Sometimes it won't say anything specifically about, how those whereas clauses should be interpreted. But the point of those whereas clauses typically is to add context, so that anyone who's looking at the agreement and isn't familiar with the parties is able to kind of understand what's going on and what the intent was. So make sure that those recitals, make sure that those whereas clauses or those that background at the beginning of the contract has correct information, so that anyone who's reading it later, like a judge, is not working off of incorrect information when it comes to interpreting that contract. You have your warranties and representations. Those kind of cover, whether you're kind of warranting or saying that the work will be up to a certain standard, or, if I'm saying that I have the capacity, or that entering into this agreement isn't affected by any other agreements that I've already entered into. I'm making a representation to the other party that they're relying on. So I'm saying this is the current situation, and the other party is relying on my representation about my situation when entering into the agreement, right? And so you want to make sure that all that information looks correct, similar to what I talked about with the recitals, making sure that that information is correct. And also when it comes to warranting certain information, that means that I'm agreeing to, I mean, we're familiar with what warranties are, right? So for a specific period of time, I'm agreeing that this is going to be the situation, whether I'm saying, for a specific period of time, I will only exclusively negotiate with you or only exclusively work with your business, whatever the case may be. We're guaranteeing that. And we need to make sure that that's a guarantee that we can back up. Otherwise, there might be consequences. Remedies covers, what happens if someone breaks their obligations under the agreement, right? So a contract may cover remedies specifically. And then we mentioned confidentiality. If there's secret information or, confidential information that's going to be exchanged, that's something that should be covered within the agreement. So just to recap, what did we go over, right? What is a contract? Well, a contract is really an agreement between two or more parties. Doesn't necessarily need to be in writing, but a contract does need to have an offer, an acceptance of that offer, consideration, so basically mutual obligations between all of the parties involved. And it has to also have mutual assent or a meeting of the minds, meaning that we've agreed to the essential terms within that agreement. Contracts are important because they create the backbone of our business relationships, and especially if we're looking to build a trusting, beneficial long-term relationship, that written agreement is going to help us establish a baseline of trust at the beginning that we can then build off of to create a relationship that is going to be beneficial in the long run. A good contract is unambiguous, it's clear, it's complete, and last but not least, it's fair. And then in terms of our essential contract terms, we kind of went through some of those, right? Talking about naming the parties, the term or how long is the agreement in force, the scope of work and payment terms, intellectual property concerns, and then what am I missing? Risk allocation, right? And then there are some other terms that we also need to cover within that. So that brings us to the end. We're here at noon. I want to I appreciate everyone joining. I know that there's going to be some folks who have got to leave. I have one more thing that I want to offer, and again, I'm going to check the chat in a second. If you have any questions, feel free to drop them in the chat, or also feel free to take yourself off of mute and jump in and ask your questions. Happy to stick around for another 5 to 10 minutes and answer questions that you may have. Last but not least, I want you to remember that the true purpose of a contract is to keep you out of court, right? We want to draft those contracts in a way that if any issues pop up, hopefully you and the person you have that contract with are able to handle it between yourselves versus having to go to court and have a court handle it for you. Because a lot of times for a small business, going to court is something that can drain your business, whether it's your money or your energy. A lot of small businesses don't survive having to go through court. And so, we want to stay out of court if possible. So draft that contract in a way that's going to allow you to solve the problem on your own. Last but not least, before I get to the questions, I want to thank everyone for attending. There is a final, there's a QR code here. That QR code is actually a offer for a free contract template. So I have several basic contract templates that I've created and that I offer through my firm. And I'm offering you the ability for 24 hours to use that QR code to access and download one of those free contract templates. So feel free to take advantage of that offer as I go through and answer questions, but want to thank everyone again one last time in case anyone has to jump. So Chris, I see that you have your hand raised. Feel free to jump in and ask any question that you might have.
Thank you. Yes, I had to jump into the car, so I'm remote. That's
No
why I raised my
worries.
hand. Yeah. So oftentimes I find that I will be working for a loose group of community people, and I don't know who to get to sign the contract because there's no organization. There's just 3 or 4 people who formed a quote committee, and they will raise money and they will pay. Eventually they might get to some kind of formal organization, but usually it's a loose affiliation of people. Should I get one person or as many as possible to sign?
Yeah, that's a good question. So I think in a situation like that where you're working with multiple people who might have some sort of like loose affiliation, the important thing to remember is that um, each of those people, if they're not like, signing on behalf of a business, an LLC or a corporation, they're not going to be able to sign anything that's going to bind the entire group, right? So one of those people signing is only going to bind that one person. So I would say in a situation where you're dealing with kind of a loose association of individuals or a loose association of businesses, even, you want to get as many of those people or organizations to sign a contract as possible. I would say ideally getting all of them to sign something like that, because that way you know that they're all responsible for the obligations within that contract, and that if anything happens, you can approach any one of them about making sure that they fulfill the obligations under that agreement.
Thank you.
Absolutely. Any other questions? All right. Well, I guess not. But again, feel free. I think I put my email address at the top at the beginning in the chat, but I'm going to drop it in there again in case anyone missed it. Do feel free to reach out if there's ever anything that I could be helpful with. Again, feel free to use a QR code to take advantage of that free contract template. But I'm sad it's over. I'm sure you could sense the energy with which I approach this topic. Like I said, contracts really are one of my favorite, my favorite topic when it comes to business and the law. I think that there's so much there to dig into, but hopefully this 60 minutes was really just a good kind of baseline, basic understanding for everyone in terms of what contracts are and how we can spot and create good ones. So wish everyone the best of luck in their business. Thank you again for attending and hope you all have a great week.